Chief Justice, shall we?
Yes, we shall. And the national president of the Ghana Bar Association, GBA, Ifwa Gate, has reiterated calls for the suspension of Chief Justice Gertrude Sackey Torkornoo to be reconsidered, warning that it sets a dangerous precedent for the country. Justice Torkornoo was suspended on April 22, 2025, following 3 petitions alleging misconduct. A 5-member committee was established to investigate the claims, but the process has been shrouded in controversy. The GBA has previously demanded the revocation of her suspension, arguing that the procedures followed were unconstitutional and violated the rule of law. Speaking at the 43rd anniversary remembrance service of the 3 High Court judges murdered in 1982, Gate warned that the Chief Justice's suspension undermines judicial independence. She cautioned against endlessly settling scores and stressed the need to shield the judiciary from undue interference.
We should be careful as a nation not to go down the slippery slope of endless revenge by justifying various acts with the refrain, but others did that too. We then rose as a nation from the ashes like the phoenix and decided to conscientiously do better by making Ghana's democracy and penchants for the rule of law admirable and attractive to many worldwide. An independent judiciary, in its true sense, is a bulwark for all who seek justice and should be jealously protected. The judiciary's foremost attraction should be its glaring independent nature, credibility, and transparency. Hence the provisions in our 1992 Constitution seeking to guarantee same. The Ghana Bar Association, as well as other legal associations, both local and international, such as the Commonwealth Lawyers Association, Commonwealth Magistrates and Judges Association, and Commonwealth Legal Education Association, as a matter of principle, have made their voices heard on the ongoing process for the removal of the Chief Justice of Ghana, Her Ladyship Justice Gertrude A.S. Torkornoo. It is hoped that any Superior Court judge will be well apprised of the entire process before ever being subjected to same in the spirit of fairness. Rising to the defense of the judiciary's independence is the mandate of the Ghana Bar Association, and this is not personality driven.
You just heard there Ifwa Gate, the national president of the Ghana Bar Association. The moderator of the Methodist Church of Ghana, Most Reverend Professor Kwabena Asamoah Jedu, has, however, chastised the Ghana Bar Association of what he described as political exposure of certain elements within the association. He called on the GBA to carry out an internal introspection to realign them to the original tenets. Meanwhile, former New Patriotic Party MPP General Secretary Kwabena Ejapong, speaking on the sidelines of the event, stated that the allegations against the Chief Justice were not serious enough to justify her removal. Over to you, Alfred.
Well, let's say a bit further on this matter. And this position by the Ghana Bar Association is not new. After their earlier meeting sometime in 2 months ago, they took this position that generated quite some conversation as well, and this is what they've reiterated. Sylvia Kuji is a senior private legal practitioner. He speaks for the Ghana Bar Association, and he's joining us on the telephone right now. Counsel, good evening. Thank you for joining us.
Good evening, Alfred. Thank you so much for the opportunity.
Why do you narrow? I hear the president of the Bar Association talk about the entire process that is ongoing for the Chief Justice, the suspended Chief Justice, to also have a hearing on the petitions against her as some sort of vendetta, that it has been done before, so let it be done this time and nothing would be wrong with it. Why do you think this entire process is about a vendetta and not necessarily one that is a process enshrined in the Constitution that is playing out right now?
Everything
on the slippery slope.
Didn't hear the president of the bar say that. She used the word vendetta, but I honestly did not hear her use it relative to the suspension of the Chief Justice. What I heard her say in her speech was that the numerous calls for the reversal of the Chief Justice's suspension should be considered or reconsidered. And my understanding of this is that the process could have still been going on without necessarily the Chief Justice being suspended. That is my understanding. So let me reiterate. I did not hear the president of the bar say or use the word vendetta relative to the proceedings ongoing in respect of the removal of the Chief Justice, because she said so many things about the murdered judges. So I wonder how one would have come to that conclusion that the word vendetta was used in respect of the removal proceedings going on relative to the Chief Justice.
And just for the benefit of, because you're referencing exactly what she said, I don't want us to also get into the realms of directly quoting her and not getting it right. I wanted to take a listen to exactly what she said, and then we'll proceed with the conversation.
We should be careful as a nation not to go down the slippery slope of endless revenge by justifying various acts with the refrain, but others did that too. We then rose as a nation from the ashes like the phoenix and decided to conscientiously do better by making Ghana's democracy and penchant for the rule of law admirable and attractive to many worldwide. An independent judiciary, in its true sense, is a bulwark for all who seek justice and should be jealously protected. The judiciary's foremost attraction should be its glaring independent nature, credibility, and transparency. Hence the provisions in our 1992 Constitution seeking to guarantee same. The Ghana Bar Association, as well as other legal associations, both local and international, such as the Commonwealth Lawyers Association, Commonwealth Magistrates and Judges Association, and Commonwealth Legal Education Association, as a matter of principle, have made their voices heard on the ongoing process for the removal of the Chief Justice.
Essentially, and she makes that point at the beginning, as you heard there, and then continues to make these comments in direct reference to what is happening with the suspended Chief Justice. But you indicate that this process could have still gone on without she being suspended. I mean, exactly how could that have played out, and why do you think her suspension in any way is not right, as the Ghana Bar Association has indicated earlier today through your president?
Well, Everett, I think these are administrative decisions that an employer, for instance, can take on an employee who is alleged to have done something wrong. You decide to suspend the person so that you can do the necessary investigation, or you allow the person still to be at post whilst you do that. So these are discretionary matters. But what I want to establish is that the use of the word vendetta was not in respect of the ongoing process, because if you listen to the president of the bar very carefully, she was giving a background of what happened in 1992, 30th of June. And giving that background, from my understanding, what happened then shouldn't be happening now, because the judiciary must be independent. But we should not say that because it had happened before, it could be repeated. That is my understanding.
I see. How is this process in any way threatening the independence of the judiciary?
I think she didn't say that. What I'm saying is this. What she said is about the whole thing about the Chief Justice, as you said, was about statements issued by various associations, including the Commonwealth Lawyers. She mentioned that. Then she went on to say that the many calls that are being made for the reversal of the suspension of the Chief Justice may have to be considered. And I said my understanding of that is that she's not talking about the process itself, but only the suspension, because if she had meant to speak about the process itself, she would have said it. And I understood it to mean that the Chief Justice could have still been at post while the processes continue.
But the Chief Justice being suspended has not violated any specific rule, has it?
It may not have, but it doesn't also take away the need for or the right of people to call for a reversal. I think people have the right to say that too.
Indeed, but what is the GBA against the 146 to 10 playing out as we are seeing in the Chief Justice's case?
The GBA is never against that. I think the concern has been that this is the first time this kind of proceedings is taking place relative to a sitting Chief Justice. That is the concern. So it is not as if the provisions in the Constitution are non-existent and cannot be applied. But the application process and the office concerned in what we're looking at, especially the fact that this is the first of its kind.
Okay, so what's the GBA's specific concern? If you're not against Article 146 to 10 playing out as we're saying now, so what exactly is your concern about this entire process?
I think I've said that listening to my president or the president of the bar, the understanding I had and still have is that the processes could have been going on while the Chief Justice still remained at post. She may not have been suspended, or there might not be a need for her to be suspended before the proceedings could go on.
But you know that would have been awkward, is it not? Because then, if, for instance, the all of these applications against the entire process by the likes of the old Tafo Member of Parliament, Vincent Assefa, all of that came, the Chief Justice would have been the one to empanel on these cases. Is it not? And so how would it have been if she was still at post and having to still play the role as CJ in these cases that were also seeking to challenge the constitutionality of a process against her?
The Chief Justice's role is that it's an administrative role. That's the way I see it. She can still remain the Chief Justice and yet decline the rule, the aspect of the rule that has to do with empaneling of judges. She can still be at post and be recruited from doing that.
But do you know that it's not just...
If that is the only concern, that she may have to empanel people to sit on cases that concern, of course, that is not the natural thing to do. So that aspect alone, she may have to recuse herself. But is that the only reason why she's been suspended? One may ask. If that's the only reason, then she could have been at post and yet recruit herself from playing that role of empaneling judges.
Well, I wouldn't want to play that role of second-guessing the reasons why, but I think it's quite clear that communication from the presidency that communicated to all of us the suspension of the Chief Justice and the processes that followed thereof. All of those thresholds had to be met for her suspension as enshrined in Article 146. But you indicated that you don't have a problem with the application of 146 to 10 as it's playing out now. But then again, your position is that she could have still stayed at post and not be suspended, and this process will still be at play. Eric Delano is the president
because your questions were based on the speech delivered by the bar president today.
Which is the
so
basis?
Looking at the content of the speech, that is what my mind tells me.
I see. But I want to find out if Counsel Eric Delano's mind also tells him in the same vein as you are thinking. He's the president of the Lawyers in Search of Democracy. I thank you so much for joining us here on Hot Edition. The position of the PRO of the Ghana Bar Association is that the Gertrude Sackey Torkornoo, her leadership, could have still stayed at post and not necessarily be suspended while this process of the hearing of the petitions against her goes on. Do you think same?
Well, I don't, but I really would not like to go into whether I think it was appropriate for her to be suspended or not. Rather, what I think all of us should be conscious of is that the authority to suspend her was there and is there. And that was why it was exercised. The Constitution says that upon the advice of Council of State, the President may suspend if they found prima facie and they establish a committee. So I don't want to go into the justification of the suspension. I don't want to go into that, although it will be ridiculous that she will still be opposed, like you said, the question you asked the PRO, she will still be opposed, and then matters are coming to the court to challenge her removal process, and then she will be empaneling. And I hear the PRO saying that, if that is the only reason that is administrative, and then she may not have to empanel. But there were several cases, several precedents where the Supreme Court says that the person who is the Chief Justice, who is acting as the Chief Justice, has to perform that administrative role. Whatever the case, the person has to do it. And so it would have been a different challenge if she were there, and then the matter goes there, and then people will begin to make the argument that, this matter concerns her, so she shouldn't empanel. That would be something else we'll be discussing. And I wouldn't be surprised to hear the Bar Association and the PRO, all of them arguing again that the Chief Justice, so he should do it. You see, and then I hear one funny argument that the PRO is making. He's saying that one of their problems is that it's because this is the first time. So would there ever be the first time? They don't expect any first time for the Constitution to be applied. There will always be a first time. So if they have a problem because it's the first time, then when shall we ever have a first time? You see, so anytime it is going to happen, they will say it's the first time, so don't do it. It's the first time, don't do it. That is what I'm reading from this. So if they don't ever want to have a first time, then we are not going to have a second time. We are not going to have a third time. And so that provision, the provision of Article 146, will never be applied. So isn't that ridiculous? So the Bar Association is struggling. They are struggling too much on this. It's a very simple matter. Look, the Constitution says that any citizen, the only way we participate in the delivery of justice is also to report if we see anything wrong with how our judges are conducting themselves. So the Constitution gives us the right and says that, look, if we see anything like that, petition. And then the Constitution says that, President, if you receive a petition, do 1, 2, 3, 4. So right now, all that we have to look for is whether there was a petition. If there was a petition, is the President acting in accordance with what the Constitution says the President must do? If he's doing so, we just have to fold our arms and watch. And the President is doing that. And then they will tell you that we don't think that they are violating anything, and yet it's the first time. So we don't want any first time. And so we will never want any second time. And so there will never be any third time. And so that provision in the Constitution should be redundant forever. It doesn't. And lawyers should not be making this argument. Ghana Bar Association should not engage itself in this kind of, I don't know, but it's just not right. So I don't believe in what they are saying. I don't think that the bar should be engaged in this kind of arguments and saying that because it's the first time, that's why it is a problem for them. And so what should we do? So the petition came, so the President should throw the petition away. The President, the Constitution, the President, and the Council of State must evaluate the petition, and if there's prima facie, they must establish a committee. So what they are saying is that the President and the Council of State, in their mind, they think there's a prima facie. They must still say that, no, there's no prima facie, or we shall not act. Is that what they are saying? Is that what they are saying? I'm not getting them. They should stop struggling to confuse the public. That's what I have to say to this.
Essentially, I asked a question about whether they have any concerns or they disagree with the application of the dictates of Article 146, 6 to 10 as it's playing out in the Chief Justice suspension as we speak. That they don't have a problem. They don't.
Yeah, I heard that the PRO says the only concern is that it's the first time. I think that's strange. It's the first time, so it should not be applied. He said that's his concern. So should they ask him again? Should he ever be applied? Ask him that. If he ever will be applied, then that time that it will be applied will be the first time anyway, wouldn't it be? So I look, this kind of argument, I don't know, you know. So the bar, you know, when they are doing this, and all of us are members of the bar, and when they are making this kind of argument, and we have to confront them or argue against their position, then it appears as though we we are being fronted, the bar, but because they are making arguments that do not make much sense to us, even lawyers, even to even the public. You are saying, look, the president has not violated any part of the Constitution. The president, when the president was elected and was sworn into office, he was given a set of laws, set of rules. That was the Constitution, and said that go and operate this. This is what we are giving to you. Implement this. And in the Constitution, it says that if you receive a petition to remove any justice of the Superior Court or the Chief Justice, do 1, 2, 3, 4. Move in accordance with these steps. The president receives a petition. Look, he didn't instigate it. Even if he instigated it, we don't know, and we cannot make the argument. The fact is that what we know is that there were petitions, 3 petitions. He received the petitions. The president is acting upon the petition. Is going strictly according to the Constitution. Until today, they cannot find anything the president has done that is wrong. And yet they are struggling. Let's find something somewhere. Let's find some debt somewhere. And they are struggling. They don't, and lawyers are struggling, bringing this, bringing that, and all of them are not making sense. They're not making sense. And so you come on radio, and then you say that, oh, well, the president is not doing anything wrong because it is the first time we don't want him to do it. It is the first time, so we don't want him to do it. So it's never been applied. So no president should ever apply it, because anytime a president will be applied, there will be a Ghana Bar Association that will say that it's the first time, so don't do it. So it's never going to be done. If that is what they want, they should tell us.
I see. Mr. Kuche, so that's the contrary view. I mean, the argument of it being a first time doesn't really bar the Constitution from essentially being applied if the first time around it to be done, is it not?
Alfred, I think that if you cast your mind by back when our resolution was passed, we were saying that there ought to have been laid down regulations before this was done. The argument be the first time. Yes, people have made it. We've also made it just because this is the first of its kind. Because chief justices have not gone through this before. So if we say it's the first time, that doesn't mean it shouldn't be done. But it is true, it's the first time. Nobody can run away from that. That is why, because you asked me a question about today's speech by the president of the bar. Her concern has to do with the suspension. She never mentioned anything about 146. And don't forget, she also made a point that processes involved must be made known to the affected people or the affected Superior Court judge. The tape you played, the sound bite you played a while ago, she said something like that.
Right. Yeah. No, but yes, she said she didn't mention 146. She referenced the suspension. The suspension is not an action in oblivion. The suspension is as a result of the implementation and execution of 146, is it not?
I agree. But let us, you see, she was specific as to what her concern was. She talked about suspension. 146 is not only about suspension, it's about other things. So if she had wanted to say the other things, she would have said them. That is my point. Because she was specific.
So what is the concern?
The cause for suspension.
What exactly is...
No, hold on. Mr. Daniel, hold on, I'll come to you. Yes, Mr. Kuche, okay. You're making a point, yes.
I was saying that 146 is not only about the suspension of the Chief Justice, it's about the whole process. And I am saying that if the bar president had wanted to mention some other aspects of the processes under 146, she would have done that. But she limited herself to the suspension. So when you called me, you said that she said they were doing it, it's going on because of vendetta. And I corrected you that she used the word vendetta, though, but not in relation to the ongoing processes involving the suspension of the Chief Justice.
I see. Well, maybe let's draw down the curtains on this. Delano, that clarification is not convincing for you still?
Sorry.
No, not
Why
at all. The suspension is part of 146. It's part of it. It's part of the process. And so if and you see, we have to understand it. It is not for us to evaluate whether the matter is weighty enough for the president to suspend or not, because the Constitution, what it says is that, look, if upon advice of the Council of State, the president may suspend, and they have done that. The president told us that he was advised duly by the Council of State, and so if anybody thinks that is wrong, the right forum to challenge it is at the court. And this whole issue about the processes must be given to the Chief Justice and all of that, these are all things that they are just pushing because they are just searching. This expedition, can we find something to obfuscate this whole process? Because it's a very simple process in 146. Even a child can just pick it and read it and see that the process is being followed. So I don't know. So they are struggling, They are really, really struggling, and I pity them, So they will do themselves good when they stop struggling and putting up all these arguments and because it's not making sense to anybody. So the president is doing the right thing because the Constitution. Because there were petitions and he has to act on the petitions. He acted on the petitions. In fact, even before he would say that the Prima Facie was determined, there were already suits in court challenging. The Chief Justice had already written and said, well, I want copies. The President gave her copies. They waited and the response came. And then in consultation, the Council of State, they came out and said that, well, we found Prima Facie. And so, well, with the warrant, we are suspending you, which is also authorized, duly authorized by the Constitution. They did that. And then the process is going on. It's going on. And so, well, they are just crying wolf. That's the way I see it. And I'm ashamed that it is the Ghana Bar Association that is doing this.
Well,
so perhaps we may have to do another press conference. Lindsay may have to do another press conference to address these things.
Anyway, we'll see how the coming days will look like on this. But I thank you very much, gentlemen. Thank you so much for joining us. Mr. Delanyo, Thank you for your time. Also to you, Mr. Xavier, could you appreciate you, as always, for joining us. Thank you so much.
Thank you. You're welcome.
Okay, now that's Xavier Kuji is Public Relations Officer of the Ghana Bar Association. Also, you just heard Eric Delanyo Atlo, who is the president of the Lawyers in Search of Democracy.
The Police Criminal Investigation Department, CID, has confirmed the arrest of Maxwell Kofi Juma